Hello, friends, and welcome to Uncivil Law, where we learn from my misfortunes. As always, I hope you'll enjoy this legal education content, and today will be the day I earn your subscription. For today's coverage, we are doing bar exam questions, because yours truly has decided to take the Texas bar. Yes, I'm going to take the bar in July. After being a lawyer for 14 years in Virginia, I'm going to take the new bar exam. This has many benefits, including potentially me being admitted to many, many states at the same time. You see, when I took the bar exam in the long, long ago, in the far, far away of 2007, there was no such thing as this like multi-state bar exam. Well, that's not quite true. I don't know exactly what we're calling it. Uniform bar exam. That's the right terminology. There was no such thing as the uniform bar exam in 2007. That's what I wanted. It didn't start to 2008, right? So in 2007, every state had its own bar exam. And you would take it, and like you'd had to take it in every state. And sometimes the MBE portion, the multi-state bar exam question, which is the multi-state part, would transfer, but you still had to do the essay questions from every state, right? So starting in 2008, some states got together, and because they were lazy, and you said, hey, you know what? What if instead of writing our own bar exam, we just, didn't? And fast forward till today, and I'm not sure how many states at this point, 30, 35, I'm not sure. It's a lot. They're all now in the UBE, the Uniform Bar Exam. So now you can take one bar exam, and you're taking 35 bar exams. This was not a thing in 2007. Okay, this was not a thing in 2007. So, like, I can get admitted to all the states at once, basically. It's great. And, yeah, Texas is a member, and, like, everyone else. California's not. New York, I think, is, which is amazing. And I forget who's a UBE member or not at this point. It's a lot of them. So I'm going to just sit for the bar exam and, like, I get admitted in 35 states or something. It'll be great. So we are doing the bar exam over. I didn't really mind it that much the first time, to be honest. You talk to a lot of lawyers, and they're like, I never do the bar exam again. I never do that shit. I'm like, it wasn't that bad the first time. Fuck you. It didn't bother me that much. I mean, some people tell horror stories like, you weren't there, man. I was at Nam, man. You weren't there, man. I was like, not only was I there, okay, not only was I there, but Virginia, unlike I think every other state in the country, makes you take the exam in suit and tie. Okay? Every state, I think, just lets you wear anything you want. Virginia makes you show up in courtroom attire, suit and tie. So don't tell me I was there, man. I took the bar exam, man. Yeah, you took it in pajamas, you asshole. I took it wearing a tie and still kicked your ass. Anyways, we're doing this. We're doing some MBE questions. We're going to do 20 of them. We'll see how that goes. And then we'll do some more of them. And also, I'm drinking tequila. It's Bar Squared, baby. It's Bar Squared. It's the new series. It's going to be great. All right, so let's do some bar exam questions. In an order to foster an environment conducive to learning, a school board enacted a dress code that prohibited all public high school students from wearing, in school, shorts cut above the knee. Because female students at the school consider it unfashionable to wear shorts cut at or below the knee, they no longer wear shorts to school. On the one hand, male students at school regularly wore shorts cut at or below the knee because they considered such shorts to be fashionable. Okay, so we got a dress code. It is on its face sexually neutral. It is in practice sexually neutral. The mere preferences is not going to be sufficient, right? The girls could wear shorts. They choose not to wear shorts. That's their problem. Female students sued to challenge the constitutionality of the dress code on the ground it denied them equal protection. Should the school uphold the dress code? Should the court uphold it? Yes. It is facially neutral. It is facially neutral on equal protection grounds. All right? Maybe we could do some First Amendment challenge. We're not doing a First Amendment challenge right now. We're doing an equal protection challenge. Okay? So that's what we're considering. No, because the school's dress code is not necessary to further a compelling state interest. That's suggesting strict scrutiny, But we don't need strict scrutiny. We're not doing a First Amendment analysis. No, because the dress code is not substantially related to an important state interest. That'd be true if it's sexually based discrimination. It's not. Yes, because the dress code narrowly tailored to further an important state interest. It is not intermediate scrutiny. Yes, because the dress code is rationally related to a legitimate state interest. D is the correct answer, and D is the correct answer because it is rationally related. It does not discriminate on the basis of sex, either overtly or covertly. So rational basis review is all you need. Let's go to the next question. The defendant was a pitcher for the City Robins, a professional baseball team. While the defendant was throwing warm-up pitches on the sidelines during a game, he was continuously heckled by some spectators seated in the stands above the dugout behind a wire mesh fence, as one does at a baseball game. On several occasions, the defendant turned and looked directly at the hecklers with a scowl on his face, but the heckling continued. The defendant wound up as though he was preparing to place the pitch in the direction of the catcher. However, the ball traveled from his hand at high speed at a 90-degree angle from the line to the catcher and directly towards the hecklers in the stands. Is this deliberate? I don't know. The ball passed through the wire mesh fence and struck the plaintiff, one of the hecklers. The plaintiff brought action for damages against the defendant and the City Robins, the baseball team, based upon negligence and battery. The trial court directed a verdict for the defendant and the City Robins on battery. The jury found for the defendants and City Robins on negligence. Because the jury determined the defendant could not foresee the ball would pass through the wire mesh fence. The plaintiff has appealed the judgment on the battery counts, contending the trial court erred in directing verdicts for the defendant and the City Robins. On appeal, the court holds the question of whether the defendants committed battery is a jury issue. The judgment entered on the directed verdict in favor of the City Robins should then be, well, let's see. They directed a verdict, but the Court of Appeals says it is a jury verdict, which necessarily means we must reverse, right? And remand. Great. Let's do that. A, reverse and the case remanded because a jury could find the City Robins vicariously liable for... Okay, so this is only in case of the verdict of City Robins, the baseball team. We're only considering the judgment on the directed verdict of the baseball team. So, but they're part of the defendant. So it's a jury question. So I'm not sure it matters either way, but we'll take note. Reverse and remanded because a jury could find the City Robins vicariously liable for battery committed by a defendant in the course of employment. That sounds promising. Reverse and remanded because a jury could find negligence on the part of Robins management. That also sounds promising. Affirm because an employer is not vicariously liable for battery. No, this is not true. In majority of places, this is not the majority rule. The majority rule is that an employer can be held liable for a employee's intentional torts committed within the course of employment. Affirm because defendant's act was a knowing violation of team rules. Was it though? We don't have that. All right, so let's see what we got. So it's A or B. Now, we are on the question of battery. So negligence is the wrong answer because negligence is the wrong standard for a battery claim. Battery is an intentional tort. So the correct answer is A. And it is A. Moving on to the next question. A defendant is on trial for murder of his father. The defense is that he shot the father accidentally. The prosecution calls a witness, a police officer, to testify that on 2 occasions in the year prior to the incident, he had been called to defendant's home because of complaints of loud arguments between the defendant and the father, and found it necessary to stop the defendant from beating his father. The evidence is, okay, we're talking about propensity evidence, people. Propensity evidence, right? We want to have the police officer testify that on 2 prior occasions he came to this domestic dispute between father and defendant, right, to break it up with respect to arguments. Now, we all know that propensity evidence is not generally admissible, but there are exceptions, of course, because it's law. And we don't know such a thing as law without exceptions, which is why we avoid words like always and never, right? And one of the exceptions for propensity evidence is to rebut an affirmative defense. For example, accidents, right? Accident, right? So you can offer propensity evidence because in this situation you are offering it to negate an affirmative defense, which is a proper reason to offer propensity evidence. So the evidence is inadmissible because improper character evidence. No. Inadmissible because the witness lacks firsthand knowledge of the people who started the quarrels. No. Admissible to show the defendant killed his father intentionally. No. Admissible to show the defendant is a violent person. Yes, because we are showing it is part of his character traits, propensity to rebut the affirmative defense. So the answer is D. Oh, the answer is C. Oh, no. Evidence of prior fights and beatings is admissible for the purpose of establishing defendant's intent or absence of mistake. Yes, I know that. That's what I said. So they're not admissible to prove one's violent character. They're admissible to show lack of mistake. So what yeah. He killed his father intentionally. Okay, so right analysis, wrong answer. Do as I say, not as I do. Next question. And you can't see the D choice. It doesn't quite scroll down far enough, does it? Let me see if I can fix that. Can I fix it? Well, not without making it a lot smaller, I can't. But it's what we'll have to do. All right. Next person is, can you make it bigger? No, I can't. It's one of the two. A construction company contracted to build a laundry for a laundry company on the latter's vacant lot in a residential area. Zoning violations? As part of its work, the construction company dug a trench from the partially completed laundry to the edge of a public sidewalk. Water lines were to be installed in the trench. Because of the contour of the land, the trench was dug to a depth ranging from 7 to 9 feet. The construction company did not place any barriers around the trench and permitted it to lie almost open for a week. Uh-oh. While waiting for delivery of the water pipes. This was known to the laundry company but raised no objection. Uh-oh. During the time the trench was open, a series of heavy rains fell, causing 5 feet of surface water to gather in the bottom of the trench. While this condition existed, a 5-year-old child who was playing on the vacant lot with his friend stumbled and fell into the trench. An adult passerby saw this and immediately lowered himself into the trench to rescue the child. However, his doing so caused the rain-soaked walls of the trench to collapse, killing both him and the child. In a claim for wrongful death by a child's administrator against the construction company, the most likely result is the plaintiff will. Okay. All right. So the major factor here I think is going to turn the analysis is that we know, okay, well, it's against the construction company. So they're just fucking hosed, right? If it were against the laundry company, our major analysis here would turn on the fact that they had actual knowledge. Yeah, in this situation, now, this is a trespasser, is one of the reasons they're asking this question, right? They're asking a trespasser. And what duties do you owe to a trespasser? And you only owe you only owe duty to known trespassers if you're, okay, so this is actually complicated under common law. All right, so let me see how well I know my common law rules. This is good times. All right, so you've got a trespasser, but it's not a known trespasser. Is it an attractive nuisance? Probably not. It's probably not an attractive nuisance, which would change the analysis again. All right, so is it an attractive nuisance? Probably not. Is it a known trespasser? No. So what duties do you have to a trespasser is what this question is asking me. All right, let's see how good my knowledge is when it comes to your duties to trespassers under common law. Okay. The most likely result is the plaintiff will recover because they left the trench unprotected. That sounds too broad to be true. Recover because construction companies are strictly liable for inherently dangerous conditions. That sounds wrong. Not recover because the child is a trespasser. Promising. Not recover because the child's death was a result of the collapse of the trench and intervening cause. That sounds wrong. I think the answer is C. They will not recover because the child is a trespasser. Now, I have to think about this really hard because I'm having to dig way deep into my knowledge of law here, right? This is not an attractive nuisance. This is not a known trespasser. So there's no particular duty. So I think the answer is C. I think they will not recover because the child is a trespasser on the common law. C? Oh, no. Foreseeable and known. Child was foreseeable and known. Was he, though? He was foreseeable. But was he a known trespasser by the call of the question? No, he wasn't. He wasn't a known trespasser. To be foreseeable, maybe, but he's not a known trespasser. Those are not the same thing. But we'll go with foreseeable. The creation of an artificial condition requires duty of ordinary care. Under the facts, knew that the residential lot is foreseeable. Would cause this foreseeable harm, had a duty of care foreseeably, had a clear duty to provide a protective barrier. C is incorrect. Has a duty of care to pedestrians who might inadvertently stray. Has a duty to protect known and reasonably knowable infant trespasser without appreciation of danger. Okay, sure. That sounds fine. Let's move on. A landowner hired a tree specialist to cut down 4 trees, which he pointed out to the specialist before the specialist's work began. Although the landowner reasonably believed that all the trees were on his property, 3 of the trees that were cut down were in fact on the neighbor's property. Who, if anyone, is liable to the landowner's neighbor for conversion? The landowner is presumably the right answer to this. Are they both liable, or is only the landowner liable? That's the relevant question. For conversion, which is the civil term of theft. I don't think that the tree. I think it's only the landowner. Oh, it's both. Damn it. This is true in common law regardless of knowledge of whether it's in a possession or not. Damn it. It's just intentional act to deprive another of property. That makes sense. Damn it. Next question. A farmer, a citizen of State A, sued a rancher, a citizen of State B, in federal district court in State B. The farmer asked the court to quiet title to a certain property in State B where the rancher currently resides. Although the rancher believes the property was bequeathed to her, she knows a cousin of hers, a man who's a citizen of State A, believes the property belongs to him. The rancher files a motion to dismiss for failure to join the man as an indispensable party. How should the court rule in the motion to dismiss? That sounds pretty promising to me. The court must dismiss the action because it lacks subject matter jurisdiction over the man's claims. And no, it should be fine. The property's in B. It's a citizen of B. It's a diversity jurisdiction, right? We don't know the value of the land, though. A might be the right answer. The court may retain the action if it finds in equity and good conscience that the case would proceed without the man. That doesn't sound right. The court may retain the action even though the man's indispensable. No. The court may retain the action because of subject matter jurisdiction over the man's claim. Why? I think the answer is A. I think they lack subject matter jurisdiction. right? The problem is there's no federal cause of action. There's no federal cause of action, and we haven't stated the value of the property. So we don't know it's over $75,000. So I think we have a problem with subject matter. So I think the answer is A. Right? Right? Okay, this is bullshit. Or maybe I'm just answering the wrong question. Maybe I'm just answering the wrong question. The motion to dismiss is on indispensable party, and I said subject matter. I answered the wrong question. That's the problem. I answered the wrong question. A is probably the right answer, but it's the right answer to the wrong question. Yeah. You're confused? The problem is the question they asked, right? In law, the question governs more than you might want to know, right? So the question was, they moved to dismiss for failure to join an indispensable party. That was the question. And then I said, oh, they should dismiss because of subject matter. But that wasn't the question. Right? That wasn't the question. The question was, should they dismiss for indispensable party? So I answered the wrong question. I didn't answer the question that was asked. The question was asked was, should you dismiss for failure to join an indispensable party? So my answer, you should move to dismiss for failure of subject matter jurisdiction, while true, wasn't the question they asked me. So it doesn't matter now, does it? So, you got to pay attention. And I didn't pay attention, so I got it wrong. Okay, a painter filed a diversity action against a doctor in federal court in State A. The painter alleges the doctor failed to pay $95,000 due on a valid service contract. The doctor does not dispute there was a contract, but testifies in a deposition that he paid the debt. The painter stated in a deposition, the doctor never paid the debt pursuant to the contract, and the $95,000 the doctor paid was for a rare sports car he sold the doctor. The trial is set next week, based only on the evidence in the record. Which party is likely to prevail at this point in the lawsuit? The painter a motion for summary judgment? No, there's a fundamental dispute of fact. The doctor a motion for summary judgment? There's a fundamental dispute of fact. The doctor a motion for dismiss for failure to state a claim upon which relief? No, it's a diversity contract. It's over $75,000 of value, so neither party on motions for summary judgment is the correct answer. It's got to be. And it is, thank God. Next question. Why does it matter he's a doctor? It doesn't matter he's a doctor. It doesn't. Are you under the impression that everything they say in the question will necessarily be relevant to solving the question? Oh, then you're in for a bad time, my friend. You're in for a bad time. Are you under the impression that everything they give you in the question will be necessary? How's it relevant? It's not. A man and his friend, who were both adults, went to a party. The man had many drinks at the party and became legally intoxicated. They decided to play a game of chance called Russian roulette, using a gun loaded with one bullet. As part of the game, the man pointed the gun at the friend and on command pulled the trigger. The man shot the friend in the shoulder. The friend brought a negligence actions against the man. Traditional defenses based on plaintiff's conduct apply. What is the likely disposition in this case? Okay. What is the likely dispositive issue in this case? Whether the game constituted a joint venture, whether the friend could validly consent to the game, whether the friend was also negligent, whether the man was legally intoxicated when he began playing the game. Dispositive. Is it likely to be dispositive whether the friend was also negligent? No, it's not likely to be dispositive. Is it likely to be dispositive whether the man was legally intoxicated? No, because he would be negligent in becoming intoxicated, so no. Whether the friend could validly consent? Maybe, although they already told us he's legally intoxicated, so... But that doesn't necessarily mean consent is necessarily invalid, because what do we mean by intoxicated exactly? And whether the game constitutes a joint venture. It's either A or B, and I'm not sure which. If he could validly consent to the game, then on a theory of straight negligence, that would be assumption of risk. They became legally intoxicated. Does that necessarily mean that they can't validly consent? Because what exactly do we mean by legally intoxicated? Whether the game constitutes a joint venture. I'm going to go with A and hope for the best. Damn it. Contributory negligence is an appropriate defense to negligence. I didn't say... But contributory negligence isn't the dominant rule anymore. But apparently, contributory negligence is an appropriate defense to negligence. Not in most states, it's not. In some states it is, but I don't think in most states it is. I'm not so sure about that one. Next question. A federal law provides that all motor vehicle tires discarded in this country must be disposed of in facilities licensed by the Federal Environmental Protection Agency. Pursuant to federal law and all proper federal procedural requirements, the agency has adopted very strict standards for licensing the facilities. As a result, the cost of disposing tires is substantial. A particular state has a very large fleet of motor vehicles, including trucks used to support state-owned commercial activities and police cars. The state disposes of used tires from both kinds of motor vehicles in a facility owned and operated by the state. State facility is unlicensed, but its operation in actual practice meets most of the standards imposed by the feds on facilities it licenses. Consistent with U.S. Supreme Court precedent, may the state continue to dispose of this tire in this manner? No. Probably not. No, because the state must comply with valid federal laws that regulate matters affecting interstate commerce. That sounds promising. No, because some of the tires come from vehicles that are used by the state solely in its commercial activities. That sounds wrong. No, because some of the tires come from vehicles that are used by the state in performance of core governmental functions. No. Yes, because legitimate needs of federal government are satisfied. No, it's got to be A. And it is A because Wickard v. Filburn is a bitch. A senator from State A became upset when he learned that residents of State A are not permitted to bring state law product liability suits against State A company in State A federal courts, but residents of State B may do so. The senator plans to introduce legislation that say federal courts shall have jurisdiction where the plaintiff's cause of action shows it's based upon state product liability law. Is the proposed legislation constitutional? I don't know. Yes, because Congress has plenary power to extend federal jurisdiction to any questions arising under federal law or the United States Constitution. Yes, because Congress has plenary power to create federal courts and determine their jurisdiction. No, because it would extend federal jurisdiction to state law claims without requiring diversity of citizenship. No, because it would not extend federal jurisdiction to defendants who invoke state products liability as a defense. It's either A or B. It's got to be. It's got to be B. Apparently not. If the Senator's proposed legislation were to pass, it would allow a plaintiff to bring suit to avoid diversity, which would be unconstitutional. Okay. A defendant has been charged with making a false statement to a federally insured financial institution to secure a loan. At trial, the prosecutor calls the defendant's wife as a willing witness to testify. Defendant told her in confidence that he means to represent his assets on the loan application. Defendant objects. Should the testimony be omitted? No. No, because even though the wife is a willing witness, the defendant has a right to exclude confidential marital communications in federal court. No, but only if the law of the state where defendant and his wife reside recognize privilege for confidential marital communications. Ooh, tough. Yes, because in federal court, the right not to testify belongs to a testifying spouse, and she's a willing witness. That sounds wrong. Yes, because while the adverse testimonial privilege is recognized, the marital communication privilege is not. That sounds wrong. I believe the answer is B. Okay. A defendant and a sports fan were engaged in heated discussion over relative merits of their favorite professional football teams. When the defendant said, "You have to be one of the dumbest people around," the sports fan slapped the defendant. The defendant drew a knife and stabbed the sports fan in the stomach. Other people then stepped in and stopped any further fighting. Despite the pleas of other people, the sports fan refused to go to the hospital or seek medical treatment. Doesn't matter. About 2 hours later, he died as a result of blood. Sucks to be you. The defendant was charged with murder. You're guilty. At trial, the medical evidence established that if the sportsman had been taken to the hospital, he would have survived. Sucks to be you. At the end of the case, defendant moves for judgment of acquittal or in the alternative for instruction on the elements of voluntary manslaughter. You're fucked. The court should grant the motion for acquittal. No. Deny the motion for acquittal but instruct on manslaughter because there's evidence of provocation. No. Deny both motions because defendant failed to retreat. No. Deny both motions because malice may be proved by intentional use of a deadly weapon on a vital part of the body. D. You've got to be fucking making. You've got to be kidding me. Oh, that's fucking bullshit. The sports fan slapping the defendant may be considered adequate provocation, and a reasonable jury could find defendant was acting in heat of passion. Because some evidence supports a reasonable find defendant's guilty of voluntary manslaughter, a jury should be instructed accordingly. So, like, basically like an imperfect self-defense. All right. A defendant was arrested on a murder charge. She is given Miranda warnings and refused to talk to police. At trial, she testified in her own defense. She recounted in some detail her whereabouts on the day of the crime and explained why she could not have committed the crime. On cross-examination over defendant's objection, the prosecution emphasized the fact that she did not tell the police the story following her arrest. This is Binger. This is just Binger. If I get this wrong, I'm quitting the practice of law. The defendant was convicted. On appeal, she claims error. Yeah. Her conviction will most likely be... Please let me get this right so I can have some credibility in this world. Reversed because post-arrest silence constituted by the defendant's exercise of Miranda rights and the use of silence against her violate due process. Reversed because to require defendant to acquaint the prosecution with defense tone, it's C. It's got to be C. It's C. If it's not C, I'm giving up. I'm just giving up. Thank God I get to still be a lawyer. Jesus Christ. A young woman joined a neighborhood gang. At a gang meeting, as part of the initiation process, the leader ordered the young woman to kill a member of the rival gang. The young woman refused, saying she no longer wanted to be part of the group. The leader, with approval of other members, told the young woman she'd become too involved with the gang to quit, and they would kill her if she did not accomplish the murder. Okay, so we're going to use duress as a defense to murder, which will not fly in most jurisdictions. The next day, the young woman shot a member of her rival gang to death, while the rival gang was sitting a member outside the restaurant. The young woman was charged with first-degree murder. First-degree murder is defined in the jurisdiction as intentional premeditated killing of another. Second-degree killing is any other murder. If the young woman killed the rival gang member because of threat to her own life, the young woman should be found guilty of first-degree murder. Not guilty because of defense duress is not going to fly in the vast majority of jurisdictions, right? There might be someone out there. There might be one out there. But duress will not get you to a murder conviction. It'll get you to a lot of things, but not a murder conviction. So that's the reason A is wrong. Necessity is just wrong. Guilty of first-degree murder. It's premeditated killing. It's A. It's C. And it is C. Yeah. Yeah. Duress is not sufficient in most jurisdictions for a murder charge. At defendant's trial for stealing an automobile, defendant called a character witness who testified defendant had excellent reputation for honesty. Okay. The defendant is calling a member for their reputation. In rebuttal, the prosecution calls another woman to testify they saw the defendant cheat. The prosecution witness should be allowed. You open the door, I open the door, right? Admitted because defendant had opened the door. Admitted because cheating involves dishonesty. No. Excluded because there's no probative value. No. Excluded because it can be in court. No. It is A. You open the door, I open the door. You've got to be fucking kidding me. It's D. What? D is correct. In rebutting the defendant's character witness, the prosecution may only ask about specific instances of defendant's prior misconduct on cross-examination. A is incorrect. The prosecution cannot use specific instances of prior misconduct to rebut the character evidence testimony given by defendant's witness, except on cross. In rebuttal, the prosecution may only inquire into specific instances of defendant's misconduct on cross-examination of the character's witness. Because defendant's honesty is not an essential element of the charge, the prosecution cannot use specific incidents of conduct to show defendant is guilty. What? Even though defendant opened the door regarding defendant's character for honesty, the prosecution cannot use specific instances of prior misconduct to rebut the character evidence testimony given by the defense witness except on cross-examination. Hold on, talk amongst yourselves. Federal Rules of Evidence, 608B. Except for a criminal conviction under Rule 609, extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support the witness' character for truthfulness. But the court may, on cross-examination, allow them to be inquired into. Wow, that's so specific, man. That is so specific. Wow. That is so specific. A witness's credibility may be attacked or supported by testimony about the witness's reputation, but evidence of truthful character is admissible. Evidence is not admissible to prove specific instances in order to attack or support witness's character for truthfulness, except on the cross. Wow. And it is a specific instance because it's referring to a specific instance of cheating on a college exam. That is so fucking tricky. That is so fucking tricky. There was no way on God's green earth I knew that one. Like some of these other ones, if I dug really, really deep into my mind, maybe. But there's no way on God's green earth I knew that one. I did not know that one. I had forgotten that one, if I ever knew it in the first place. All right, so let me tell you what just happened so I can explain it to myself. Wow. Okay. This is so fucking tricky. All right, let's go back to the question. At defendant's trial for stealing an automobile, the defendant called a character witness who testified the defendant had an excellent reputation for honesty. In rebuttal, the prosecution calls another witness to testify that he recently saw the defendant cheat on a college examination. The prosecution's witness testimony should be excluded because Defendant's cheating can be inquired only on cross-examination of defendant's witnesses. Yeah, this is some unbelievably pedantic bullshit over here, but they're right under the rule as I looked it up, right? They're right. So yes, you open the door for character testimony, which means I can bring in witnesses to testify about your character in general. Wow. I can bring in witnesses to testify about your character in general. But I can't call witnesses to talk about specific instances of dishonesty. I can only do that via cross-examination. I cannot do that by calling my own witness. Wow. Wow. How pedantic is that bullshit? How pedantic is that, right? So you open the door, and I can bring in 8 witnesses to say, in general, how you're a bad person. But if I want them to testify, I saw him cheating at that specific thing. No, can't bring that in. I only can bring that into a cross-examination question. Wow. Wow. That is some pedantic bullshit right there. Unbelievable. Woof. 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 Wow. That is some specific pedantic shit right there, man. Thomas says he feels like a lot of judges would have messed that up. No shit, Thomas. No shit. No shit, judges would have fucked that up. I'm not sure I ever knew that one in the back of my brain. Holy God. That is... Woo! You don't understand how you can enter evidence into cross-examination? You can ask the question, though. You can ask the question. But you can't bring it... But, you know, it's so easy to get around this because you just don't have to ask the specific question, right? So you can bring it, you can call the person, you can ask, do they have a reputation for dishonesty? Yes. I know them to have a reputation for dishonesty. They do dishonest things all the time. You just can't ask what specific dishonest things they do. So if the answer is this one time at band camp, no, you can't do that. Apparently. Okay. Who's really bad? Is Keith saying I'm really bad? Who's really bad? Is Keith calling me really bad? It's not, who's really bad? Before putting her home up for sale, a homeowner painted the living room ceiling to conceal major water damage caused by a leaking roof that had not yet been repaired. Oh, the defendant? Yeah, okay, that makes sense. Before putting her home up for sale, a homeowner painted the living room ceiling to conceal water damage that had not yet been repaired. Sounds like some fraud, possibly. On first day the home was offered for sale, the homeowner gave the buyer a personal tour. The homeowner made no statements at all regarding the water damage or the roof. Without discovering the water damage or leaking roof and without consulting a lawyer, the buyer immediately agreed to writing to buy the home. Before the closing date, the buyer discovered the water damage and leaking roof. The cost of the repair was estimated at $22,000. The buyers refused to go through the purchase. If they sue for breach of contract, is the homeowner likely to prevail? No. Absolutely not. No, because no contract was formed since the buyer did not have a real opportunity to understand essential terms. No, because homeowner concealed evidence of the water and of the leaking roof. That sounds very, very promising. Yes, because homeowners make no affirmative statements about the fact. No. Yes, because buyer acted unreasonably by failing to employ an inspector. No. So, a real opportunity to understand essential terms. No, they understood the essential terms. The problem is the concealment. It's B. Yeah. A residential building was expanded into a vacant lot north of its original location. The contractor who was working on the restaurant expansion found the north wall of the new structure needed extensive support, so anchor rods and concrete walls were added. The supporting anchor rods and concrete extended into a neighboring property farther to the north at a point 20 feet below the surface. Okay. Although there's no impact on the surface of his land or existing uses, the owner of the property has sued the restaurant owner for trespass. Yeah, I mean, that should work. Which party is likely to prevail? The neighboring property owner, because she should have been given notice before it incurred. The neighboring property owner, because the restaurant intruded without permission. That sounds right. The restaurant owner, because the decision to provide additional support was reasonable. No. The restaurant owner, because of no disturbance of peaceful enjoyment. No, it's trespass. So it's B. And it is B. Michael Palmer says, for some unknown reason, it won't let me super chat. This may be more of a systemic problem. I was on with Law of Self-Defense, and no super chats were going through with him either. So maybe it's more of a systemic YouTube problem. I don't know. American Legend said, yup, upgraded. This has been a great community, and I'm proud to have been here for 1 year tomorrow. Excellent. I'm glad to hear that. Stephanie's here. Hello, Stephanie. As always, I hope to hear from you. I just want you to know I miss you. I like talking to you. And I hope to hear from you more. Do you own infinity below your own property? At common law. And to the sky infinitely. Of course, that's been abrogated a little bit since, airplanes, but in common law, yeah. And I don't think that's been abrogated by statute. So, yeah, you own all the land below you forever. That's where mineral rights come from, for example. Let's go to the next question. Section 1 of the Vehicle Code of a state makes it illegal to cross a street in a central business district other than as a designated crosswalk. Section 2 of the code prohibits parking any motor vehicle so it blocks any part of the crosswalk. A pedestrian wants to cross Main Street in the central business district, located in the state, but a truck parked by the trucker was blocking the crosswalk. A pedestrian stepped out in the Main Street and carefully walked around the back of the truck. The pedestrian was struck by a motor vehicle negligently operated by driver. Okay. If pedestrian asserts claims against the driver, the pedestrian's failure to be in the crosswalk will have which of the following effects? Okay. It is not relevant to determining the rights of the pedestrian. It may be considered on the issue of driver liability. Promising. It would be considered express assumption of risk. That sounds wrong. It will bar recovery as a matter of law. That sounds wrong. I think it's going to be able to be considered. To say it's not relevant seems wrong. It may not ultimately go anywhere, but it's relevant, right? I mean, relevancy is a pretty low bar, right? Just for something to be relevant, it just has to potentially move the needle one way or another. It just has to, in some degree, make you more or less liable or more or less guilty. That's all that relevance means. It just has to potentially change the needle in one direction or the other to potentially some degree. It's not much. So, to say it's irrelevant seems wrong. To say it can be considered seems right. So I think the answer is B. And it is B, thank God. Kurt is still staying lean and mean. Thank you for asking. I didn't make it to the gym today because I had sleep issues last night. I will make it to the gym tomorrow, and I'm still posting on Instagram, so make sure to follow me on Instagram and follow my workouts. They've been going very, very well, and I thank every one of you for your encouragements because it helps me continue to go and make things possible, and I really do appreciate that. Thank you. Yeah. Oh, look at my text messages? Oh, I will. I always like to look at my text messages, Stephanie. Am I going to cover the laundry suit? Oh, I probably will. It sounds like bullshit. I talked about it a little bit with legal bites. It is totally bullshit. But yes, I will talk about it at some point soon. And yeah, Stephanie has had a loss in her family, and I don't know how much she wants to talk about it, but I'm obviously here to support her. As always. Just remember, guys, Stephanie's mine, and I will fight you for her. All right. Next question. A city has an ordinance that prohibits the location of adult theaters and bookstores. Theaters and bookstores presenting sexually explicit performances or materials in residential or commercial zones within the cities. The ordinance was intended to protect surrounding property from likely adverse secondary effects of such establishments. Okay. Adult theaters and bookstores are freely permitted in the area of city-zoned industrial, where those are not as likely. Okay. A storekeeper is denied zoning permit to open an adult theater and bookstore in a building owned by him in the commercial district. As a result, the storekeeper brings suit in appropriate challenge. All right, so let's think about this logically, right? So we are restricting based on the particular subject matter in play, right? Adult subject matter. It's a state regulation or government regulation on subject matter. So probably strict scrutiny. So we're thinking a compelling governmental interest in least restrictive means. Doesn't necessarily mean we can't meet it, but we just got to pay attention to these things, right? I'm just trying to see what's going on in chat here. Anyways, it's a time, place, manner restriction. It's worse than that, though. It's specifically based on adult content. Yeah, so it's specifically based on the nature of the content. It's not a time, place, manner restriction. It's a subject matter restriction. It doesn't mean we can't get there, but still, it's worse than that. The ordinance is valid because the city may enforce zoning restrictions on speech-related businesses to ensure the messages they disseminate are acceptable. That sounds like bullshit. The ordinance is valid because the city may enforce this type of place, time, manner restriction on speech-related businesses. So long as the type of regulation is designed to serve a substantial interest, does not unreasonably limit alternative revenue. The ordinance is invalid because the city may not enforce zoning regulations that deprive potential operators of adult theaters and bookstores of the freedom to choose location. That sounds just wrong. The ordinance is valid because the city may not zone property in a manner calculated to protect property from likely adverse secondary effects. Shit, none of these answers sound right. None of these answers sound right. A is wrong. C is wrong. It's got to be B. It's got to be B. It does. B's wrong, but it's the least wrong answer there. B's wrong. B's bullshit. Fuck the church. A plaintiff domiciled in State A sued a defendant domiciled in State B, alleging defendant had failed to deliver products to plaintiff under an ongoing contract. The plaintiff attached to the complaint invoice for products marked paid and receipt for a wire transfer defendant in the amount of $80,000. Defendant answered the complaint, denying plaintiff had suffered any loss and asserting a counterclaim for non-payment of $90,000 for earlier delivery. In response to the counterclaim, they moved for judgment as to pleadings. I don't know. Renton versus Playtime, they applied intermediate scrutiny, time, place, manner restriction. It's specific. Stephanie, how are you doing? By the way, I just want to make sure you're doing okay. I'm going to pass this because I don't really understand it, and I'm just going to pass. And this looks too long, and I'll pass this too. Let's try another one. A toy collector had purchased 10 antique toys over the last several years and had them restored by an expert in toy restoration. On June the 1st, the collector sent an 11th antique toy to the expert with a signed note that read, "Here's another toy for you to restore. As with all prior jobs, I'll pay $500 for the work, but no more." On June the 4th, after receiving the collector's June the 1st note and the toy, the expert began restoring. On June the 6th, the collector unexpectedly died. On June the 7th, unaware of the collector's death, the expert sent the collector a note stating the restoration work had begun on June 4th. The following day, they learned, does a contract exist? Yes. Of course it does. Yeah, I mean, there was partial performance on the contract at the time of death. No, because the collector died before the expert sent the note. No, because the offer lapsed. Yes, because the expert sent the note before learning. Yes, because the offer was accepted. That's the right answer. The offer was accepted by the partial performance. It's D. It's D. I answered 20 questions. How'd I do? 1, 2, 3, 4, 5, 6, 7, 8. Oh, Christ. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So I did 55%, which is not ideal, but it's, so, I need some practice, but, that's all right. 55% for starting it's all right. 55% of 20 questions. Overall 60% on this particular thing. I'm still above the average of users. 74 questions deep. I need further work. Yeah. No, I need further work. Well, 55 of the 20 answered. I skipped 2, so it's fine. Don't have to make it up at the essay portion. I have no intention of making it up at the essay portion. I have every intention by the time I take this bar exam of blowing it out on the MBE. It's one of the reasons I'm practicing. Am I okay? You've looked like you've had a few. I'm a little okay. I'm just wanting to make sure Stephanie's okay, to be honest. Yeah. These are all apparently actual bar exam questions, by the way. And we did definitely learn something about the very strong nuances of character testimony that we wouldn't have otherwise known, so... Yeah, it's a UBE state. It's Texas. It's all UBE. It's all UBE. You have to pass each section. Cannot make one or the other. Have to pass both. No, you don't. No, you don't. You absolutely can. What are you talking about? You can absolutely just... No. Unless you know something I don't know. But unless you know something I don't know, you can make it up on other sections. I don't think so. I'll be taking it in Texas. Why not? Take it in Austin. If 55 isn't bad, it could be better. I did pass the bar exam. I passed for Virginia many, many moons ago. Yeah, I passed Virginia many, 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 many moons ago. Many moons ago. I've been a lawyer for 14 years, but I'm taking the Texas bar, and the UBE, which didn't exist when I took the bar many moons ago. So see if I can get all the states. That'll be good. But I am licensed in Virginia. The bar is in July, so that's 4 months. UBE is the Uniform Bar Exam. Yeah, the Uniform Bar Exam. It started in 2008. I took the bar exam in 2007. But in 2008, some states started saying, you know what if we didn't do the bar exam? Like, what if we didn't write it? And fast forward 20 years later, and a good half the states plus at this point are on the Uniform Bar Exam, so they all just use model essay questions and model written questions. So basically at this point you can take one bar exam and get admitted into half the states, which was not a thing when I took the bar exam in 2007, let me tell you. California is not UBE, that's true. New York is, surprisingly, though, for some reason. You have to take it in person. Yeah, you have to take it in person. Is Florida UBE? I don't know. Let's look up what states are UBE. Let's look it up. I don't know what states are UBE. Let's look it up. Yeah, so... Yeah. So let's take a look according to Wikipedia. Alabama, Alaska, Arizona, Arkansas, California to some degree. They still have some local administered components, though. Colorado, Connecticut, District of Columbia, Florida, Georgia, Guam, Florida. Yeah, I mean... Virginia is still not UBE, apparently. 37 jurisdictions. California and Florida are not. Florida has not adopted it. New York has, apparently. Yeah, so it's 37 jurisdictions. That's a lot. Take a look at the jurisdictions on the UBE website. Shut up. Alabama, Alaska, Arizona, Arkansas, Colorado, Connecticut, D.C., Idaho, Illinois, Indiana, Iowa, Kansas, Kentucky, Maine, Maryland, Massachusetts, Michigan in 2023, Minnesota, Missouri, Montana, Nebraska, New Hampshire, New Jersey, New Mexico, New York, North Carolina, North Dakota, Ohio, Oklahoma, Oregon, Pennsylvania, Rhode Island, South Carolina, Tennessee, Texas, Utah, Vermont, Washington, West Virginia, Wyoming, and the Virgin Islands. So, pretty much everyone is the answer to that question. I'm going to call Stephanie now, because I'd rather talk to Stephanie than your lot. It's yeah. Louisiana is not on there because Louisiana is a civil law jurisdiction. So yeah, they're in their own little world of pain. Yeah, Hawaii's not on there. But, you know, New York is on there as of July 2016. They're a big one. Virginia's not yet. They'll cave eventually. What kind of law I'm going to practice? Haven't decided yet. I don't know. I haven't decided yet. All right, I'm going to call Stephanie now. If you've enjoyed this stream, please remember to like, comment, subscribe. Do all the YouTube things. I'm going to make this members only. This is going to be a members only benefit stream once it's over. So I hope you enjoy that. Until later, my friends. I hope. I'm done with patent law. I'm done with patent law. I think I'm done. So yeah, I think I'm done. So I'll get back to you guys later. Till later, my friends. Cheers and goodbye.